May I be permitted to mention monthly list item number 459? My lord,
Yes, what do you want?
my lord, actually, what has happened is this, my lord. Like two application has been filed before the learned presiding officer, challenging the validity
What
of.
do you want?
But I want, my lord, the hearing. It's the expeditious disposal matter. Your lordship can take up other side. It not be, my lord. It's the expeditious disposal.
Hand over the slip. Yes.
I permit to mention to file this application
Hand over
without
the slip mentioning the urgency.
leave to file this
Write it down.
application without certified copy, Lordship.
What is the urgency?
Urgency, Lordship, 151 application. Police has been help has been allowed, Lordship, by directing the plaintiff to
You have got the server copy.
a server copy, Lordship.
Leave to file with the server copy.
File without the typed copy. The handwritten copy order will not.
Why?
Sir, certified copy, but handwritten.
Certified copy.
There is one more.
With regard to item number 3, my lord, on behalf of Mr. Bhattacharya, Tapos Bhattacharya.
Item number 3, what do you want? Please wait at the time of call.
But there is one more matter, my lord. Item number 699. Here, my lord, your lordship had the matter directing me to serve.
What do you want?
My lord, I want hearing, my lord. Because the urgency is this, my
Please
lord.
hand over the slip mentioning the urgency.
I'm mentioning in parcel matter. This is my personal matter. I'm saying leave to file a revisional application without certified copy. This is server copy, my lord.
My lord, extension of interim order.
Extension of interim, please hand over the slip.
My lord, extension of interim order. Item number 1052 of your lordship monthly list, my lord. I shall not troubling your lordship, but my lord, the urgency is that this today is, my lord, kindly, my lord.
Mention the
Today is the
urgency.
last chance, my lord. Otherwise, the suit will proceed, my lord.
Mention the urgency, hand over the slip.
Kind leave, my lord, I am seeking only leave to file this revisional application without including opposite party, my lord. By the order impugned, my lord, the suit got abated. My application for appointment of Administrator General has been rejected.
Leave to file.
Order item number 20, my lord.
20. Yes, what do you want?
In this matter, in connection of this suit, your lordship appear on behalf of the opposite party.
On behalf of the opposite, you are for the petitioner. Item number 20.
20.
20 তে একটা order করে দিন. Since I am not inclined to take up
The 18th has been mentioned in my presentation slip. Ex-party lordship police help application.
18th.
Yes. Can it be taken up tomorrow on notice, lordship?
18th, Mr. Chakravarti, it will appear on 18th.
No, but lordship, the police help, lordship, order has been passed, and now, lordship, the police station is saying that they will execute any day, lordship. Maybe tomorrow.
What is the decree will be executed?
Yes, by way of police help, by a put-up petition, lordship, ex-party police help was allowed, lordship.
ওটা কালকে দিয়ে দিন.
Upon lordship, there is a caveator. I have also, lordship, sir.
Please inform the caveator that it will appear tomorrow.
Yes.
হ্যাঁ কি মেনশন কেন কালকে মোশনই কালকের ডেটেই করে দিন.
It had mentioned.
Chakravarti, do one thing, please. The file has come.
But by today, it will be in your lordship.
Yes, scholar list.
Item one, Lordship, I beg to appear for the petitioner. This is my application praying for expeditious disposal of my application filed under Order 7, Rule 11, Lordship. The next date which is fixed before the learned trial court is 29th of April 2026.
29th of April.
Last date today, 29th of April 2026. Lordship, in this matter, I have also filed an application under section 151 for tagging of both the suits. Item number 1 and item number 2 are similar kind of cause of action, because what has happened, your lordship, the
Tagging that cannot be done here. I can only direct these applications to be heard. This application under Article 227 of the Constitution of
Similar,
Similar. Date is also same.
no, date is different. Date is, oh, Lordship, I apologize, Your Lordship. The last order has not been annexed because during the pendency of the incident application under Article 227, what has happened, Your Lordship, the next date was fixed on 25th of August. And on that day, we had appeared, but the learned court was not there. For this reason, the matter was fixed on 22nd of June 2026. So the order is not there. If Your Lordship kindly grants me a leave, I shall bring on record that.
No, all right. So what is the next date fixed?
22nd of June 2026.
22nd of June 2026. The order 7 rule 11D.
Order 7 Rule 11D, also 151 has filed for
Also
preponing and tagging of the
One
suits.
same. ঠিক আছে? Matter.
Deeply obliged.
The team Lord on behalf of Mr. Tapan Bhattacharya, I pay not this week.
Better than proceed on.
Yes, yes. What is this? Yes.
Mr. Bhattacharya is appearing.
Which Mr. Bhattacharya?
Tapan Bhattacharya.
Ask him to come. Ask him to come.
He on behalf of him, Lord.
Sir, you have challenged an order of 2016. Yes, since I'm not this application under Article 2. Next.
Practically, Lord, he is busy, Lord.
Maybe ask him to come. Otherwise, I will dismiss this application. 2016 order in 2025.
2016 sort of Lord challenged by the.
Ask him to come. If you are ready, you can move that. If you are ready with the matter, you move that. Otherwise, ask him to come. Yes, yes.
Well, Mr. Gupta, Mahendra Gupta appearing matter, my lord. He did not come the court, my lord. Kindly make it not today, my lord.
The issue that arises for consideration is
My lord, an ejectment suit.
yes.
In this suit, the defendant, after appearing, did not deposit the admitted area of rent for the 3 months. Subsequently, an application under section 151 was filed, and that inherent jurisdiction under section 151 was allowed.
The issue that arises for consideration.
My lord, advocate on record of the petitioner could not come to court today, my lord, due to personal difficulty. I am praying for not today, lordship.
Yes, yes. Please move the matter.
My lord, I am not briefing this matter, lordship. Advocate on record could
Then
not.
why are you praying for adjournment? If you are not briefed in this matter, don't pray for an adjournment.
And,
Where is Mr. Anand Banerjee?
my lord,
Ask him to come, pass over.
with
Yes,
lordship.
call the next matter.
The key item number 3, my lord.
But
Mr.
item 3, but
Please wait, Mr.
candid confidence, I have not yet, I've got the brief also. I have not yet read
Please go through the brief. दिए दिन तो which item number?
item 3, my lord.
Item 3, my lord.
Item 3 brief का दिए दिन. Mr. Bhattacharya, I am told that you are appearing. Please, short matter, you can get yourself ready. Yes, yes. Who is appearing?
Sir, kindly fix it on Wednesday, my lord. Kindly fix it on.
Otherwise, my lord,
Mr. Bhattacharya, please go through the brief.
for other reason, my lord, for other reason, for other reason, my lord.
No, no,
Your lordship
please.
knows,
Please go through the brief first. Then I will consider.
code number 9 has
All right.
Acha,
Come from court room 19.
Sir, kindly fix it on Wednesday, my lord.
He will be ready.
He is
Don't
not
know.
ready, my lord. He is,
5 minutes time, he will get your paper. Yes, yes. Who is appearing in this matter?
sir, kindly fix it on Wednesday, my lord.
Ask him to come, then I will consider. This application under article none appears for the petition at the time of. Yes.
You know, बोला था.
Yes, yes.
In this matter, my lord, I am appealing for the opposite party. My lord, when your lordship was in the bar, your lordship appears.
I am for the petitioner, my lord. Mr. Kalidashar is appearing for this matter. He has not arrived yet. I am seeking for a short pass.
হেরে গিয়ে আমার বিপদটা করে
This application under
application.
Yes, Mr. Chairman.
I am the plaintiff in the suit, my lord.
Yes.
I have filed an application. Initially, I sent the notice, my lord, for rejectment. But thereafter, my lord, I filed a suit for recovery of possession, my lord, on the ground of that he is defaulting. The defendant opposite party, they appeared and they filed, my lord, one application under section 7.1 and 7.2 of the Withdrawal Premises Act 1997. After taking evidence, my lord, which was allowed. Against that order, my lord, I have come up before your lordship.
What is the suit for?
Suit for recovery of possession, ejectment, suit for eviction.
Eviction on what grounds?
On the ground of non-payment of rent.
Only on the ground of default.
Yes.
Mr. Chatterjee, what is the infirmity in the impugned order?
Well, they have defaulted in payment of rent since 1991.
They have paid before the rent controller. They have paid before the rent controller. All receipts have been produced. That's the finding.
Your lordship, kindly see the impugned order.
Yes.
First page.
Yes.
First page, my lord. The last but one paragraph.
Yes.
The London lawyer for the plaintiff opposite party, by filing written objection, had contended that the defendant is liable to pay area rent since 30/11/1991, as he was not paid any rent. So he paid for rejection of the prayer for the defendant petition.
Yes.
But subsequently, they paid the rent.
Yes.
Before the rent controller.
Yes. So there is no
I-
default. There is no default. All amounts have been paid. Only only this.
All amount.
Only
My
this.
contention is
3 months there was default.
And my contention is that they have defaulted in payment of rent since 1991. But I filed a
He is a tenant according to English calendar month or Bengali calendar month. Show me the rent receipt.
Well, rent is at the present moment. I have not. Whether if your lordship directly.
Sir, you are saying according to English calendar month, they have produced rent receipts that they are tenants in respect of Bengali calendar months.
Well, that is correct. Bengali calendar. That is correct.
So, and these amounts have been paid. This is the finding. How can I go into the factual findings? In 227.
Let them survey copy.
Nothing. Asun, this application under Article 227 of the Constitution. Yes.
Lordship, on behalf of the petitioner, I'm praying for a short passover.
Today Passover is difficult, madam. Please start.
Um, um, Lordship, in a ejectment execution proceeding, the petitioner before your Lordship has filed ejectment appeal along with a stay application, which is still pending for disposal.
When did you file the ejectment appeal?
Uh,
When did you file the ejectment appeal?
it has been filed, Lordship.
When the decree was passed?
It's Lordship, the decree was passed on August, just a minute. I don't have hard copy, Lordship.
Yes, who is leading you?
Mr. Oshi Gordon Raut.
Ask him to come. Passover. Yes. Yes.
Defendant is the petitioner before your lordship. Here, my lord, the order impugned before your lordship is being challenged after a long delay. But I have explained what happened. My lord, initially in the suit, my lord, is for declaration that there is a, my lord, public drain which has alleged to have been, my lord, encroached and construction being made. I denied the existence of public drain over there because I
You are
say
the plaintiff.
I am the defendant. I say the plaintiff's house.
The plaint.
The plaint is at page 13 of my lord's brief. My address is, my lord, 252 by 4 Poncharantala Road. Now the plaintiff's residence
Your
is
address is?
my lord, page 14. My lord, kindly see defendant number 1, 252 by 4 Poncharantala Road.
Yes.
Your lordship has got it. Now the plaintiff's address in the schedule your lordship will get. My lord, it's 124 by 1 Shodor Bokshi Lane.
Yes.
I mentioned in the written statement that the plaintiff's house is at least below 30 houses in between are intervening, and there was no public drain at all as per the survey and town map. This is my case of written statement. Now kindly takes up page 31 once.
Yes.
Not kindly takes up page 31. Your lordship will get it is an application filed by the plaintiff himself, though the caption is 39.7, but they prayed for survey pass advocate commissioner to be appointed. Has your lordship got it, Milord? Page 31 as well as the prayer portion. Kindly see, Milord. Page 34. 31 and 34 both. They caption 39.7, but Milord, they have prayed for appointment because Milord, the conspectus of the suit is that the appointment of survey pass commissioner is essential. Has your lordship got it, Milord? Now, Milord, kindly takes up my written objection. I am not troubling for your lordship for the time being. Kindly takes up, Milord, the order impugned before your lordship. Why I am on delay, Milord, I will explain thereafter immediately. My lord, kindly see this application is being considered and our advocate commissioner has been appointed. An advocate commissioner has been appointed who is not a survey knowing person. Now, my lord, she went there. She filed a report. Ex parte commission was held, though my prayer for adjournment was there on board. So, my lord, when the report comes up, I filed that I could not be able to participate in the commission process. So, ultimately, the learned judge, my lord, again directed a commission to be held. That order has been interfered by your lordship, my lord, in the revisional application preferred by the plaintiff. Lord, I have annexed that order, page 44, my lord has interfered. Page 44. The direction for second inspection to be done by the advocate commissioner. This revisional application is being served. The client contacted with me, my lord. Immediately upon showing the records, my lord.
No, which order was stayed?
My lord has stayed the second order by virtue of which the learned judge has directed. My lord, I am carrying that revisional application.
Second order is 9th of June 2025. 9th of June 2025.
Yes, my lord.
That order has been stayed.
Yes. 9th of June. Kindly takes up that revision. 9th of June.
Yes.
This is Milord the again direction was being passed for holding inspection afresh. My lord has interfered. But I am on a basic premise, my lord, when the plaintiff himself asked for survey past commissioner. Whether this exercise can be done by an advocate commissioner to be appointed over here. Like after the service of this revisional application,
It can be by advocate commissioner, may not be survey passed.
Milord, that
May not be survey
it has
passed.
to be, Milord, because the
You
allegation.
want survey pass?
Yes.
So I am appointing survey pass.
That's Milord. I will serve the revisional application. I am not praying even Milord
But
any
the survey
interim
pass
protection.
commissioner has been appointed. Mr.
No, Milord, not survey pass. Milord, that's why Milord.
Show me the
Yes,
order.
yes, Milord, kindly takes up the order impugned before your lordship.
Yes.
Milord, 9th of January 2023, has your lordship got it, Milord?
Yes.
She has been appointed. It's a lawyer commissioner, Milord.
Yes.
It was not.
So what is the dispute with regard to the boundary?
Yes, that's not boundary. Milord, kindly takes up, Milord, the plaint.
Yes.
The plaint allegation is that they initially came up before this honorable court by filing writ petition. Thereafter, FMAT. All these, Milord, battle was there. Ultimately, it has been held the existence of the drain that has to be proved. In my written statement, kindly takes up now page 23.
So according to you, there does not exist any drain.
Yes, and his allegation is that.
Mr. Mukherjee, please allow me to understand this. Please kindly come to the plaint. Plaint.
Yes, Milord.
Schedule B is the disputed drain. Schedule B is the disputed drain.
Kindly takes up, Milord, where it is situated.
Schedule B is the disputed drain. Now, one drain of Howrah Municipal Corporation in the eastern side,
Yes.
which is part and parcel of a scheduled property.
Yes.
So, a scheduled property, there is
This
no
Sodar Bokshi, yes.
there is no dispute. So, on the eastern side, the learned advocate cannot decide which is the eastern
His
side.
case is not that. His case is that I am stretching that drain is coming up to Pancharamtala Road.
Where is that?
Yes.
Show me that allegation in the plaint.
Milord, my address, kindly
No,
see.
show me that allegation in the
I'm
plaint.
coming, Milord. My address, kindly see. I will
Yes.
show before your lordship the plaint as well as written statement case.
Yes,
Milord,
yes.
I'm not. Milord, kindly takes up, Milord, the page 14. My address is
52 by 4.
Now, Milord, kindly takes up, Milord, paragraph 2.
Yes.
The defendant number 1 who has or had been interrupting the outlet of the Howrah Municipal Corporation's drain by passing dirty and such water through the drain of the Howrah Municipal Corporation in the eastern side of the B schedule mentioned property. It is such and such, Milord, kindly turns over. Paragraph 6. That the
Yes.
plaintiff state that such and such the defendant number 1 interrupted the outlet of the Howrah Municipal Corporation. It has to be Milord drain in the eastern side of the B schedule mentioned property in these reasons that the pollution is creating heavily hazardous and the neighborhood and the obnoxious emitting. A different type of mosquitoes and such is as spraying. The defendant number 1 sons went to the local police station. Milord, this is Milord, the allegation of mine to be Milord. Paragraph 11. Kindly takes up paragraph 11.
Yes.
The plaintiff states that the bathroom of the plaintiff number 1 is totally damaged because of the polluted water is gathered in the bathroom of plaintiff. So, Milord, it's my water which has been, Milord, polluting the bathroom of the plaintiff. My Milord, gathered from the bathroom of the plaintiff. So, Milord, that why the plaintiff did not use the bathroom repairing must be necessary for using the bathroom for illegal act and activities of the defendant number 1. Now, Milord, kindly takes up my written statement.
Yes. Page.
Milord, it starts page 23, kindly takes up page 26.
Yes.
Paragraph 17.
Yes.
Has your lordship got it, Milord? That the statement made in paragraph 6 of the plaint are totally false, such and such. The answering defendant submits that at present he is residing. Milord, kindly now marks.
Yes.
252 by 4 Pancharantala Road and just adjacent western side of the municipal holding number 252 by 3 by 1 and just contiguous west 252 by 3 Pancharantala Road belongs to Ashima Mukherjee, Amit Mukherjee, Tripti Mukherjee and Ruma Banerjee. And in that two holding, there is nor municipal drain or Sorkari drain is passing through the contiguous north of 252/4 Panchanantala Road, the municipal holding number 248 Panchanantala Road
So
is
your
situated.
specific case is that
Yes,
there is no municipal drain or Sarkari drain passing through a contiguous
and I have
north of
given the boundaries of also of my premises and who are the adjoining owners of that. And Milord kindly takes up thereafter paragraph 20 once. Has your lordship got it? Milord, paragraph 20 at page 27.
paragraph
20.
Yes, at page 27.
Yes, Milord.
Yes,
Milord, this defendant submits. Milord, has your lordship got?
yes.
Second line, whether the wife of the plaintiff number 1 sent such and such to the conservancy department of defendant number 2, such as now the important part, the municipal holding number. Milord, last line of 124/1 Sodor Bokshi Lane. Behind from the municipal holding number 252/4, 252/3, and such, and there is a gap of at least 30 feet in length between 124/1 Sodor Bokshi Lane premises and 252/4 Panchanantala Road.
So, Mr. Mukherjee, if that is so, so according to you, there are a gap of at least 30 feet
at a length, and
so there is also no municipal drain.
At the premises of mine, existence of any municipal drain.
Yes, so there is a question of your blocking the drain.
I am not also to that. But your lordship knows, in a survey town plan, if there is a Sorkari or municipal drain, that has to be there delineated in the plan. So consultation of that plan and comparison of that stretch of area has to be looked into by measurement. This is something, Milord, which cannot be done, Milord, by mere eyes. It is not that, Milord, a municipal drain existence of which is not being disputed and its length and breadth not being disputed. The learned advocate commissioner will go and see only whether there is a blockage or not. Here, the very existence of drain, the stretch of the
Mr. Mukherjee, if there is no existence of any drain, there is no question of any blockage. The advocate commissioner can go and see that there is no existence
of application of there also.
So there is
paid for that.
There is no existence of drain. Your specific case is that there is no existence of any drain.
And
if that is so, then the advocate commissioner can go and see.
Milord, for Milord, scientific investigation is not at all necessary.
Scientific investigation is not necessary. Only an advocate commissioner will go and see, find out whether there is any existence of any drain. How are you prejudiced, Mr. Mukherjee?
Not today, what I am on. Not today,
because your specific case is that there is no existence of any drain
at my place. At
your place. So
that was kindly takes
because
now.
Mr. Mukherjee, their allegation is that you are passing some water through that drain, which is creating blockage to his bathroom.
I'm on.
That is his allegation. So and
no, kindly takes up not the points of inspection.
No, plain case. Plain case. I will come to the part of
inspection.
I will come to that. Plain case
does not even not say or canvas before the court what is the stretch of that drain, where it flows. Nothing has been stated. He said contiguous to western side of my property there is a Sorkari drain and there is a blockage to the Sorkari drain by me. I say there is no existence of Sorkari drain in Milord the four corners of my property. I butted and bounded. I say who are the next door neighbors of my Milord property. I have named them. I said there is no existence of drain. I say in the country and town planning also map there is no Sorkari existence. So consciously they have paid for a survey pass commissioner to be appointed by the plaintiff himself, so that the existence of very drain as well as the encroachment as alleged by the plaintiff can be pointed out. Kindly see Milord the point of inspection also. Page 35 of my lord's brief, Milord.
Yes.
Kindly see what they have stated. They have prayed whether there is a drain constructed where it's his premises, it's my premises. Drain constructed. Now, so the existence of very drain and it is a Sorkari drain has to be looked into by the advocate commissioner. Yes, it is a drain constructed and it is maintained by the municipality. This thing has to be done. Next, the inspection and to report as to the existence of public drain. Lord, kindly mark it. So it is not about the existence of a drain. It is a public drain and the nature of blocking, if any, if so find as to who is responsible for such blockage. Next, how the blockage can be removed for safety of the plaintiff petitioner as well as the public residing in the around the locality from the means of such and such. So, the existence, whether it is maintained by the municipality, this is something which has to be done. I am not shying away. They have prayed for the local investigation to be done by the survey past commissioner. I also say, yes, let it be done. But very existence of drain, whether it is maintained by the municipality or not, this is something which has to be tallied with the survey plan, not town plan, which is there maintained by the municipality. It is something which cannot be done by mere eyes. The existence of something where there is a 30-feet stretch that has been prayed and the court appointed, it's the courts kindly takes up my objection also. I have taken that point also.
Yes.
Paragraph 10, page 42.
42. Yes.
I say it has to be done, Milord, by the appointment of survey past commissioner and not under Order 39, Rule 7. And they have prayed for also. But I have shown before your lordship the prayer portion. Survey past commissioner plaintiff also prayed. But the learned judge, Milord, have appointed the advocate commissioner. Today I am here because they also, it's not a dead chapter because they come up before your lordship. Your lordship already interfered with regard to the inspection to be done by a fresh. Now the learned judge is of the view, trial court is of the view that since I was not present at the day when there was a heavy rain was there, I prayed for an adjournment, so I should be given an opportunity. So a de novo thing will be done. Why not a de novo thing will be done in a proper way? That is where I am on. So if that revisional application will be hard out by this, ultimately if he is of the opinion of your lordship that this thing can be done, so this thing can be done in a right manner. For that, not the present revisional application.
So your allegation is not against inspection, but an investigation
I'm
investigation by a survey past.
That is their prayer also. It is. I say it's both the parts.
Mr. Mukherjee. Yes, take it back. Yes, call the next matter.
And for the petitioner, madam, it is an expeditious hearing of the mishap in number 63 of
Arising out of
a title suit.
Injunction
Application order
Yes,
39, order 39 rule 4 was been dismissed. So I am the plaintiff in the petitioner in the plaint, and here I am in the misappeal. I am the respondent number 1. The misappeal is
You are the respondent number 1.
1 in misappeal.
But the other respondents have not been served.
Another another issue is that other respondent has not been served. They have not issued the SR, and one of the
For
respondent.
expeditious hearing of an appeal cannot be passed unless the said.
Malad, I am showing you one thing. Malad, come to the page 36.
Yes.
Their intention in the page 36, number 6, Haru Bachar. Haru Bachar died, and his name his legal heirs have been added in the plaint, but here the names are not there, so he couldn't be served. And another thing is,
Take those points in the miscellaneous appeal. Take those points.
Another thing has, during the status quo, there is a status quo order, but during the status quo order, the appellant are making the construction in the suit property.
Take steps for that. This application under Article
Well, kindly-
Yes.
But the decree holder is the petitioner before your lordship.
Decree holder is the petitioner.
Decree holder in a suit for eviction. My lord, what happened? Suit decreed. My lord, the Park Street property, my lord, suit decreed. My lord, the third party came in, filed an order 21 rule 99, canvassing his independent right title interest in respect of the suit property. That third party again filed a suit during pendency of that miscellaneous case against me. My lord, I must be candid. First, my lord, that the order 21 rule 99, my company, where I am a director, is my lord, the parties. In respect of self-same, my lord, subject matter of the property, my name, my lord, arrayed as a personal capacity, my lord, the suit has been filed. Suit filed, my lord, for permanent injunction in respect of the self-same property. I filed an application under section 10 showing that these two parallel proceedings cannot be go on. I could have filed my lord, order 7 rule 11 also, because the law suggests that this my lord, he has to come under the umbrella of order 21 rule 99 to 101. But in case my lord, the stay application is being moved, that has been turned down by the learned trial judge in the order.
That's the best course open, Mr. Mukherjee. Why are you not resorting to order?
That my lord, section
that's
10
better.
Section
10 might be a difficulty
because
party, as you have said, decree holder is a different person.
No, not
here.
decree holder, my lord. The third party is the same. Suit
Yes.
property is the same. I am also same.
There is a different thing altogether.
Not different, my lord. It's my company where I am a director.
Maybe. So maybe, but he has chosen to proceed with this suit against one of the directors.
Not one, the sole director.
Only the sole director.
That's why, my lord, the
sole director.
Some property.
Can there be one director of a private limited company?
These, two, no. Oh, both was alive at that point, but thereafter one of the director died. Now, my lord, kindly
So
text.
there cannot be only one director of a private limited company.
No, এখন আরেকটা আছে? কে আছে? Lord, kindly takes up the suit plaintiff for page 11 of my lord's brief. So both the director are here in the suit.
Both the
Page 11.
directors have been included.
Yes, yes.
As said, one of the directors.
No, no, no.
That struck me.
Yes, no.
How can that be one
Rishi and
director of a
Chandra.
private limited company?
So, my lord, this is, my lord, in respect of the page 11. Has your lordship got it, my lord?
Just give me a minute.
Paragraph 2 of page 12, my lord, if your lordship wants to look, sir. Page 12, my lord. Why I say the conspectus is same? My lord, I have shown before your lordship page 11, where Rishi and Chandra, my lord, these two are, my lord, in a personal capacity. But paragraph 2 kindly takes up.
Yes.
It is to be noted that plaintiff is a tenant under Karnani Properties Limited. Karnani Properties Limited is the company. So, my lord, in the essence, or my lord, in the texture of both these proceedings are same property, same party. If that be so, my lord, whether, my lord, the court has a power, my lord, to stay this proceeding under section 10 till the disposal of, my lord, order 21 rule 99 proceeding, which I have also annexed before your lordship, page 51 of my lord's brief.
What is the stage of this suit? What is the stage of this suit?
Peremptory hearing.
Peremptory hearing.
Yes.
Written statement filed.
Yes.
Show me your written statement of this suit.
Page 21 of my lord's brief. Milord, I have paragraph 17 kindly sees, Milord. I have also already, Milord, mentioned paragraph 17. Maybe be German, Milord, why your lordship is not inquiring me, Milord, in respect of the written statement. I have specifically pleaded about the existence of the prior suit, execution case, his order 21, rule 101, pendency, everything I have narrated. Then
Yes.
and the impugned order, Milord, has two parts, Milord. Milord, kindly see, Milord, it's a suit initiated in the year 2014.
This suit.
This suit. Now, Milord, an amendment taken up. Milord, they are taking, Milord, all dilatory tactics, how to, Milord, 122 of my lord's brief, an amendment was taken up at this matured stage.
Now, Mr. Mukherjee, your effective relief lies in the expeditious disposal of that miscellaneous case.
That is also, Milord, there. What they have done, they have filed a section 5 application in respect to order 21 rule 99 proceeding. I never heard, Milord, in respect of an original proceeding section 5 application. That is, Milord, that is pending before your lordship in the monthly list.
That's a different.
The fourth time, my lord, 4 years, last 4 years, that section 5 hearing, the evidence is going on. That is, I also approach before your
Mukherjee, it's
lordship of
better
that.
that this suit proceeds to a great extent. Otherwise, nobody knows what happens there.
That also they
That
couldn't
is
be able
why-
to do.
that
Kindly
is why
take up
it's
page
better.
122.
Mr. Mukherjee, please apply your mind.
I-
Better not to pay for stay of this.
I also, my lord, kindly takes up page
Because
122.
if you can get this suit dismissed, then also, you know, I cannot.
But
say-
I understood, my lord, kindly
So-
takes up page 122, the second limb of the order impugned.
122.
Yes, in 2024, after a lapse of 10 years, this amendment was taken up. After starting of evidence.
After evidence comments, trial comments,
Yes,
evidence adduced,
just adduced. Yes,
documents marked as exhibits.
yes, yes, yes.
Have you checked up, Mr. Mukherjee?
The kindly takes up, my lord, their application. They
I'm
have
asking you, have you checked up that the documents have been marked as exhibits? If there has been commencement of trial,
This is the PH board, my lord.
say so.
তুই কি বলছিস তুই? What?
Yes.
No, I'm just not giving that, my lord. My
Yes,
junior is
yes.
taking. Mal kindly takes up, my lord, page 122.
122, yes.
Kindly takes up, my lord, this is an application for amendment in after 10 years. The schedule of amendment starts at 131.
It's better, Mr. Mukherjee, in this type of proceedings.
Kindly takes up.
The more the interrogatory applications will be filed, it will be better.
But my lord, I will
It
be
will be
at the
better.
loggerhead. My lord, I couldn't able to proceed 2199, not even in this suit. After 10 years, this kind of longish amendment.
Yes, yes. What is the amendment sought for?
Page 131 schedule. Again, my lord, the same story that with regard to the Karnani mentioned, there is an association form. So they have given a rent to the association, don't have any privity with the owners, but given a rent to the association, they said these factors, nothing is being spelled out. All these stories of 76, 2002 suit, all these things are prior to 2014. And my lord, they want to now bring it on record, my lord, without giving any explanation.
So there is a receiver special officer appointed by the court.
Receiver special officer with regard to the, my lord, there was a electricity disconnection. Huge, my lord, payment was not being made to the electricity authority. Electricity disconnection was there.
The rent was directed to be paid to whom?
Now, my lord, the receiver is only with regard to the, my lord, the payment of, my lord, the electricity charges.
No, please kindly come to 7F.
And maintenance.
Please kindly come to 7F. Page 134.
134, my lord, yes.
Yes, yes.
Yes, this is a, my lord, I will show before your lordship.
Who had been paying rent and other charges to the court appointed receiver.
I will, that's why, my lord,
That's the specific
I will
case.
show before your lordship that order 21, rule 99 application, they have pleaded the same thing. They have pleaded the same thing. So, my lord, this was well within their knowledge. Page 51 kindly takes up. Same pleading, they have pleaded.
Mr. Mukherjee, this
My lord, there
since the evidence has not yet started.
my lord, there has to be some diligence.
These are the proceedings. You ought to have, did you point out with regard to this
Everything
in the written statement?
in my,
Show me that you have pointed out
my lord,
this.
what is not pleaded, what is,
Mr. Mukherjee, this they said that in the
I will
proceedings, special officer was appointed, they are paying rent and other charges. Those are necessary for the purpose.
I will share before your lordship that order 21, rule 99 proceeding, which has been initiated simultaneously with this in 2014. These things are well within their knowledge. They have themselves pleaded in order 21, rule 99 application. So this is a ploy. I have pleaded everything to order 21, rule 99. So it is within our knowledge. With their knowledge, they again filed a suit in 2014, and after 10 years of amendment, they waited for this, and the same facts which was pleaded in 2199, they want to rewrite it here.
Commencement of trial amendment is
But
liberal.
something has
Court
to
has to be liberal. You file a additional written statement, Mr.
additional
Mukherjee.
written statement.
These facts are
Facts was within their knowledge.
maybe-
But kindly takes up
maybe
their,
Mr. Mukherjee, you are saying
this is
those were within their knowledge at a belated stage. You know the recent decisions. It says even at the
Consent
affiliated-
decision also says, my lord, prejudice. If it is prejudice the other side,
Yes.
Lord, it's really malafide. It's really prejudice me. That rider, the Honorable Supreme Court, I am carrying, Lord, that also, the Honorable Supreme Court, that rider even given in a pre and post trial amendment.
Yes.
Even in a pre-trial amendment also, the Honorable Supreme Court said, if the other side is prejudice and it's a malafide
Yes,
act.
yes. Prejudice,
Absolutely malafide act,
has
my
to
lord.
be, has
Yes,
to be
Lord, it's
rejected.
absolutely malafide, my lord. If I can able to demonstrate before your lordship, a person while persuading his application under Order 21 Rule 99 have pleaded all these facts within their knowledge in 2014 itself.
Mr. Mukherjee, there are two things. One, if you want, I can allow you to file additional written statement. I can expedite this suit.
But my lord, section
I can
10
expedite.
proceeding, Lord, this suit expressly is not maintainable. Kindly consider that aspect. Lord, a person.
If it is not Mr. Mukherjee, if it is not maintainable, you take steps according with law.
Lord, that
If it is not maintainable for that, section 10 is not for that.
no, Lord, section 10, why the person is persuading the two remedies, Lord, at the same time. Kindly consider this aspect. The all parties are same. The property is the same.
Parties are not the same.
Yes, Lord, I said, Lord, paragraph 2 of the
Parties are
case
not the
himself.
same. Mr. Mukherjee, parties are not the same. They are the company. Here is the
They
director.
themselves said, Lord, paragraph 2. That's why I have shown before your lordship. Kindly see. If the paragraph 2 is not there in their claim, your lordship is absolutely right. Kindly takes up paragraph 2.
Yes.
What right he is asking? That he is a tenant. Under whom? Under the company. Kindly see paragraph 2.
Yes.
Is it not malafide, my lord? Paragraph 2, he is a tenant under the Karnani Properties Limited. And kindly see Order 21 Rule 99, Karnani Property Limited is the, my lord, the decree holder. He wants, my lord, I will run, my lord, pillar to post. He will file all after another, my lord, malafide application before the court and asking, my lord, adjudication of that. When, my lord, the Order 21 is specific, but he cannot file this suit and maintain this suit also. I say, my lord, adjudication will be the same. He is resisting the decree, saying that I have an independent right. Here also he is asking for permanent injunction on the basis of that right against Karnani property.
আসুন
Lord, the petitioner, this is my application for expeditious disposal. Lord, we have filed this title suit in the month of May 2023. Written statement has been filed. The suit has reached the stage of peremptory hearing. My Lord, we have deposed
and we have been partly cross-examined. In the meantime, the opposite party number 2 have filed an application under Order 3, Rule 1 and 2. And the same is pending since July 2024.
This application under Article 227 of the Constitution of India is at the instance of the plaintiffs praying for a direction upon the yes, for the next matter.
But here your lordship appeared for my client, Lord, page 38.
Sam,
Page
has been-
38, Lord.
has been yes,
No, very,
this matter is difficult.
very.
Yes,
Great.
for the next matter.
My lord, I am answering for this petition. My lord, the petitioner filed an application under Order 1, Rule 10 of the Civil Procedure Code
Yes.
before the learned trial court, and that application was rejected. My lord, kindly see at page 34 and 35, my lord, the application. And
Where is your application? Who are you?
I am for the plaintiff petitioner, my lord.
You are the plaintiff petitioner.
Yes, my lord. Application at page 34, my lord. 34 and 35.
Yes. Why have you filed this application at such a belated stage?
My lord, during the stage of evidence, my lord.
Exhibits were in your
My lord,
this application under Article 227 of the Constitution of India. Yes, Mr. Giri.
Maybe your lords.
Yes.
Right, my lord, the degree holder, plaintiff degree holder filed this petition before your lords. The execution case was dismissed on the ground of limitation. But the learned court below has not considered that then when the degree holder, while going to take possession, they have restrained in the year 2017. From that day, the plaintiff degree holder has filed the execution case. But your lordship knows, my lord, as in when the obstruction made by the judgment data, so my lord, from the date of obstruction, my lord, the execution case be maintained.
Under what provision?
My lord, one judgment, my lord, reported in 2005 Rajasthan, page 77. Your lordship knows.
No, I do not know. Please show me.
Judgment as your lordship.
Please show me.
Yes. One judgment. Your lordship.
Show me the
Kindly
decree.
consider.
Show me the decree first. Show me the decree.
Degree 2000. 2000.
Decree for?
Degree for declaration, permanent injunction and recovery of possession.
And the period of limitation. So, Mr. Giri, you can sit tight for 20 years.
No.
Then on one day, you can go to take possession, obstruction, limitation will start running from that date. Please show me the provision.
The plaintiffs are the predecessor interest of the.
Whatever it might be, Mr. Giri, please show me that provision of the Limitation Act, which says that.
You lordship know the article 136 in the Limitation Act within 12 years. But one thing, my lord, as in when the obstruction made by the judgment data from
What?
the
Where
date
is
of,
the Mr. Giri? Obstruction is from the day of passing of the decree, because you have got a decree for recovery of possession.
Yes.
So you are not in possession.
Certainly. But one thing, but sir, this judgment your lordship can consider it. Your lordship kindly paragraph 15.
Yes, show me.
And my lord, before puja, your lordship cannot.
Before puja?
Before puja, your lordship give me chance to serve. But there is no question of, my lord, stay. But there is no question of stay. Only a sharp copy. Because 15, in this case also similar situation was occurred. But unfortunately, my lord, one copy is my lord, don't be amiss, my lord. One issue, my lord, as in when from the date of obstruction, I may be permitted to file or not. This is the issue, only issue. Your lordship give me chance to serve, then after vacation, as your lordship desire, my lord. But before vacation, your lordship cannot dismiss this case. I am praying before your lordship can. Give me chance, one chance. My lord, otherwise, I will not get the fruit of the deed. Your lordship knows. My lord, the plaintiff is the father. He died. After a lapse of I searching the copy. And as in when I go to take possession, I am the son.
That is why, Mr. Giri, I told you. So, a decree for recovery of possession, you got a decree. You can sit tight over the decree for 20 years.
I agree with your lordship.
On one morning.
My lord, I am agree with your lordship's view, and my lord, under Article 136 is. But one thing, as in when my lord, the Rajasthan High Court's judgment say, and also my lord, Supreme Court says that as in when you obstructed the degree holder can from the date of obstruction within 12 years can file. But this is the authority. Your lordship can give me chance. I'll serve them come before your lordship again. But ultimately whole purpose will be, my lord, futile, because the degree my
Where is the
parents
decree?
have.
Where is the decree, Mr.?
Degree has, my lord, kindly see.
You have not annexed the degree, Mr.
Yes.
Where is that?
My lord, degree annexed A, my lord, kindly see 13, page 13. My lord, is a handwriting. 15 December 2000. and degree was passed ex parte. So your lordship, give me chance.
Decree was passed ex parte, it was in your favor. You are saying decree was passed ex parte.
No, I mean, I am saying, I am
You
submitting.
are agreed by that decree.
No, no.
So
The degree says.
you are raising a grievance, decree was
No,
passed
no,
ex
no.
parte.
I am praying
Ashun,
for
Ashun,
the
Ashun, this
lordship.
application under Article 227 of the Constitution of India is at the instance of the decree.
Take back the judgment.
Why? Let
19
it
your
remain.
appear for the petitioner.
Let it remain because I have to correct those.
Lordship appear for the petitioner.
Then take the, then just now when I am taking.
Yes, yes.
Lordship, before going into the order impugned, your Lordship, I am the owner of a hotel, your Lordship, paragraph 7, page 9.
You are for the opposite party, Mr. Chatterjee.
Led by Mr. Ram. Led by Mr. Chatterjee.
Yes.
Lordship, I am the owner of a hotel named MS Aristocrat International Private Limited, which is stated in paragraph 7. Lordship, thereafter, paragraph 9
Paragraph 7 of the plaint.
of the civil division.
Civil division application.
Lordship,
Looking through the averments of the civil division application.
Lordship,
Rarely
there are
go
two,
to the-
Lordship, kindly, Lordship, kindly hears me on facts for 1 minute. 1 minute.
Yes.
The owner of a hotel, Lordship, kindly takes paragraph 9, page 9 of the civil division.
Yes.
That Gauri Shankar Sharma, he is the plaintiff in title suit 1175, was appointed as one of the directors of the hotel such and such, and he showed interest to take over the company and its business and its erstwhile manager as an agreed amount. That sometimes in November 2024, various meetings were held with such and such between both, Your Lordship, the next page, by purchasing over the share of the hotel for valuable consideration. Accordingly, our MOU was also entered, that there was a certain amount agreed to be entered into. Lordship, thereafter, I'll only point out the
Where is the board of the
relevant portions. Lordship, thereafter, paragraph 11. In order to take over the shares, the amount of rupees 30 crore had to be handed over, and there were subsequently 3 checks which were handed over. 2 crore, 2.50 lakhs, 3 crore. This amount could not be disbursed at any point of time. Now, Your Lordship, from where the suit of 1175 of the plaintiff is arising. Lordship, kindly straight away come to page 77.
Yes.
77, 30th September 2024 is the letter of intent. This is the document on which 1175 has been filed by the plaintiff, where they have prayed at page 55 of their suit 1175 for a decree for declaration that the letter dated 3rd July 2025 issued by the defendant number 1, a company, for cancellation of the LOI dated 30th September 2024. So that was the declaration that this LOI, which was cancelled. Now, Lordship, this LOI, Your Lordship can see the date and kindly sees, Your Lordship, the entire amount. For 100% share, the entire amount, Your Lordship, has to be paid. Lordship, the next page, page 78. Rupees 8 crore.
Yes.
Lordship, the total consideration is rupees 30 crore. The page 77, third para. Total consideration amount of rupees 30 crore. So this was the total consideration amount, and accordingly the LOI has to be executed term by term. Lordship, thereafter the next page, page 79. 3rd July 2025.
Yes.
This is the cancellation of the LOI. It was served upon Gauri Shankar Sharma, the plaintiff, and he has his due knowledge on 3rd July 2025. After the 3rd July was given to him, he prefers title suit 1175. Lordship, now coming to his suit, which is annexed at page 40. Page 40, Your Lordship may kindly see, the plaintiffs are Gauri Shankar Sharma and Mrs. Shushila Sharma. Now, Lordship, my first submission is that Gauri Sharma had entered into the LOI, not Shushila Sharma. However, in their prayer portion, Lordship kindly takes the prayer, which is at page 55 of their suit. For a decree of declaration that the letter dated 3rd July 2025 issued by the defendant number 2, that is me, for cancellation of LOI is LOI dated such and such, is illegal, arbitrary and such. For a permanent injunction restraining the defendant from initiating and or giving effect to any proceeding before Registrar of Companies for removal of the plaintiffs from directorship of the Aristocrat International Private Limited. So by the time he has filed the suit, he was already, it was intimated to the Registrar of Companies, ROC, it was uploaded. It is well within their knowledge.
Now, subsequent to this suit, they have also taken out an injunction application which starts from page 59.
Yes.
59, Your Lordship. Now, the prayer portion is at page 74. 73, page 74. 74, Your Lordship. Restraining the defendant from initiating and or giving effect to any proceeding before registrar of companies for removal of the plaintiff from directorship of aristocrat till disposal of the suit. So this was the nature of injunction. Next, restraining the defendants and or their men agents from causing any obstruction in the day-to-day affairs while running the hotel business and management of the defendant number 1 company, which is being allowed to the plaintiff to be looked after in accordance with MOU dated such and such. This MOU was cancelled. Subsequent to this plaint, the order which was passed is at page 80. Page 80, may I place, Your Lordship? Page 80 is an ad interim injunction. The learned advocate for the plaintiff moves this application filed under Order 39, Rule 1 and 2 of CPC for an order of ad interim injunction against the defendant. That the suit is for declaration and permanent injunction, no caveat is lying. Lordship, thereafter coming to the ordering portion. That the instant application filed under Order 39, Rule 1 and 2 of CPC for an order of ad interim injunction against the defendant is heard and allowed in part. The defendant, their men and agents hereby restrained from obstructing the running of the hotel business over the suit scheduled property for the plaintiffs till 24th October 2025. So this is the fate of the suit wherein they were no more the directors of the hotel. The LOI was cancelled. It was updated in the ROC. Lordship, all such they have not yet challenged. Now, subsequently, Your Lordship, this is an order of 19th August 2025. Lordship, now I'll be placing 2 dates.
19th of August.
August. This order was passed after the cancellation was given. 3rd July 2025. It was cancelled, but that was not placed before the learned court below. And this order was obtained under grossest form of suppression. He was at that point of time no more the director.
Are you challenging this order of 19th of August?
No, there is a subsequent order of September.
So this order is not under challenge.
Lordship, the order of...
Have you taken any steps against this order?
They have already filed an appeal. Appeal heard, appeal admitted, the next day was given in the appeal, misappeal. And that is part of the annexure here.
Yes.
Now, Lordship, subsequently, another suit was filed, which is at page 81.
Who has filed this suit?
Lordship, I have filed it. Lordship, here the petitioner is, plaintiff is the petitioner before Your Lordship. The Aristocrat International Private Limited. Page 81.
Yes.
Now, this is my suit, Your Lordship. I'll be placing the prayers. Lordship, the prayer is incomplete here. Lordship, the order which is passed.
Where is the, which page is your prayer in the suit?
Page, Your prayer is, Your Lordship. Page 94.
94 is the prayer for injunction.
Lordship, injunction.
It's not the plaint.
No.
That is also incomplete.
Lordship, it was incomplete. The papers, I could not get it. Lordship, now an order is passed which is at page 99.
Page 99.
99. This is my suit. The same court is passing the order. Civil Judge Junior Division. I'll also indicate, Your Lordship, this transaction has now crossed rupees 1 crore 9 lakhs. So it's the order being passed by the Civil Judge Junior Division. I think perhaps the pecuniary jurisdiction is still 15 lakhs, no? 15 lakhs or senior division, it starts from 30 lakhs, Your Lordship. The transaction is of rupees 1 crore. Already there is a transaction of rupees 1 crore 9 lakhs. Gauri Sharma has paid. And the LOI cancelled because 30 crore he could not pay. for transfer of directorship. This is the matter. Now page 99, your lordship, title suit 1190, I have preferred. Lordship kindly sees the ordering portion. That the instant application filed under order 39 rule 1 and 2 for an order of ad interim injunction against the defendant is heard and allowed in part. Similar nature of order. Both parties are directed to maintain status quo in respect of running of the business of the plaintiff company till 31st October 2025. Lordship, these are the two orders which were passed by the same court. Now, Lordship, what is happening here, Lordship? Now, page 107. Page 107 is the misappeal against order dated 19th August 2025. It is an order of 28th August 2025. Appeal preferred.
You have not filed any 151 for police help?
No.
Of implementation of your ad interim order?
Lordship, Lordship, for I am there. I am running the hotel business.
This order,
Status quo. I have obtained the status quo.
but yes, for implementation of this order of status quo, yes.
Not. Lordship, thereafter coming to the order impugned.
Yes,
Lordship, which is starting from page 126.
yes.
May I place the order in the entirety?
Yes. 4th of September.
4th September 2025. Now it is passed in their suit. Today is fixed for hearing of the application under 151 CPC filed by the plaintiff on 1st September 2025. Both sides filed Hajira. The learned advocate on behalf of the defendant filed a petition. Petitioner is wrongly written, praying for granting time for filing written objection against the application. The learned advocate on behalf of the plaintiff raised strong objection and submitted before this court that the purpose of filing the application will become infructuous if the same is not heard today. Considering the nature of the application, the same is taken up for hearing. The learned advocate on behalf of the defendant showed a good conduct and was ready for making verbal submission in the application filed by the plaintiff. The petition under 151 is taken up for hearing. Now on. The learned advocate for the plaintiff stated that, and after filing of the instant suit, the plaintiff moved this application for an ad interim injunction, and the same was allowed by this court. Now the plaintiff has alleged that the defendant, in spite of having knowledge of the said injunction order, is violating the same. The learned advocate on behalf of the plaintiff submitted before this court that an email was sent to their customer denying the reservation and prayed for implementation of the order through police help. Otherwise, the hotel business of the plaintiff will be hampered. Lordship, pausing here for a moment. It is not the hotel business of the plaintiff. 1 crore for a transfer of directorship which was cancelled by the cancellation order, a cancellation letter of 3rd July 2025, and that was not placed while obtaining the subsequent order of 19th August. It was never stated before the learned court, and it was an ad interim order, so I could not appear and place the similar facts. Lordship, thereafter, the learned advocate on behalf of the defendant, that is my client, verbally submitted before this court that the plaintiff has suppressed that an appeal has been preferred against the order dated 19th August 2025 while making the application, and another case was filed by the defendant being titled suit 1190 of 2025 where an order of status quo has been passed. The learned advocate on behalf of the defendant has submitted that the plaintiff has no status as director of the company. In this capacity, they filed the instant suit and submitted before this court that there is no violation on the part of the defendant of the order of this court, and there is no urgency in implementing the order with the help of police, and prayed for rejection of the application. Now, on perusal of the order dated 19th August 2025, it is found that the court granted an ad interim injunction on being satisfied that the prima facie the plaintiff, after perusing the material on record and documents submitted by the plaintiff. The court is of the opinion that until and unless the order passed by the court is modified or set aside by appellate court, this court finds no bar in executing its own order. While an allegation has been raised by the plaintiffs that the defendants are making an attempt to violate the order of ad interim injunction, has violated the order of this court does not find any bar in directing the police to keep vigil so that order passed by the court is obeyed by the defendant. Moreover, there is no question of the defendant being prejudiced if no violation is made on this behalf. Now, your lordship, strict vigil was a part of it. Now it's ordered, hence it is ordered that the plaintiff's fare for grant of police help for implementation of the order of ad interim injunction is allowed. That the inspector in charge of Newtown police station is directed to keep vigil whether the order passed by this court is violated by the defendants and render assistance to the plaintiff for implementation of an order of ad interim injunction. Now, subsequently passing of this order, on 13th of September itself, Gauri Sharma, along with 25 miscreants, has come to the premises and forcefully they were trying to enter. Police help and all this, they had not sought for the police help. Lordship, they had come. Accordingly, your lordship, we have filed an FIR on that very day because the security personnel of the hotel, was beaten up at the entrance. Now, lordship, what is my submission on this, your lordship? On the date of passing of the order dated 19th August 2025, the declaration which was prayed in the suit pursuant arising out of the LOI, that LOI was cancelled. And the plaintiff has nowhere before any forum has prayed for implementation of the LOI. Citing the existence of the LOI, he has prayed for a declaration that he is a director or he was a director or he should be inducted as a director. That issue was kept open. The learned court, as an interim relief, granted that he should be allowed to participate as a director in the functioning of the hotel. Now, your lordship, at that relevant point of time, he was removed from the directorship.
Yes. Anything more?
Lordship, thereafter, subsequent to this is a subsequent order. 21st August was a subsequent order where the similar court, the court of...
Yes, you have placed those.
Lordship.
Yes,
It
yes,
is a-
Mr. Chatterjee.
Lordship.
There are 2 points for your lordship's kind consideration.
Any decisions you want to rely upon in your support?
Lordship. No.
Yes, yes, Mr. Chatterjee.
So can you turn to the affidavit portion?
Where affidavit? You start from the affidavit of the civil division application.
No, there is a reason here. There is a reason. And I have been instructed, my lord, by my senior, my lord, to place this before your lordship. Sees Shomiran Odhikari,
Yes.
son of late Madan Odhikari, aged about 40 years, by occupation Hindu, by occupation service, working at Dongfang such and such. And that I am the petition number 4 in the instant case, and as such I am well acquainted with the facts. This case, I have been duly authorized by the other petitioners to affirm. Now, who is the other petitioner, my lord? Number 1 is the company. The authorization, my lord, is not before your lord.
There's no board of.
There is no board resolution, there is no authorization, there is nothing. There is nothing. But he is petitioner number 4, so that's one part of the matter. Second part of the matter, my lord, is on the merits. My lord, the good, bad, indifferent, the order of injunction has been passed, and it's a definite order of injunction. It's not just an order of status. Once there is a definite order of injunction, my lord, it has to be implemented, my lord, in whatever way it's possible. That's been done by the learned judge. But we are armed, my lord, by this judgment of your lordship's court. My lord's judgment is something that we wanted to find out, but we have it, my lord, unchanged. It's a, kindly do not criticize the judgment, my lord, but if your lordship.
Okay.
But it said that if there is an order of injunction ad interim, citing to earlier division bench judgments, my lord, it said that it needs to be, my lord, implemented. There's nothing beyond this. হ্যাঁ এটা মেরিটে এখন কেন বলবো না
So whether, my lord, I am a,
Please give
I'm
me a
sorry.
minute. This was identity order of injunction, Mr. Chatterjee.
Yes.
Show me which paragraph says that it's an identity order of injunction.
What's in the first line?
An interim injunction.
Lord, it doesn't say ad interim, but
There's a distinction between ad interim and temp.
An interim injunction.
Interim injunction, not ad interim. I've seen that.
no, that the next line will say so. The said order of injunction is still in force.
Yes.
That is why, my lord, your lordship will find
Mr. Chatterjee,
that would
there
not
are
have
two
come in.
things. There are two things. One is first instance that ad interim order is passed. Second is, yes, that is being extended from time to time in the presence of others.
That's exactly
but
what the
not-
next line was.
Yes. So, but here is a case where it's the first order of ad interim order of
Yes, my
injunction.
lord, but it's a definite injunction.
Yes, yes. That is a different thing.
If it's a definite injunction, my lord, you cannot say that there is an injunction and I will flout it. That can't happen. My lord, if it was something vague, I would have
Son of
understood.
another judgment is sitting behind.
So, your lord, that's my lord's order. We have it. So
Paragraph
if it's
26.
a definite injunction, my lord, it needs to be implemented. If something vague, I would not have troubled your lordship. So here it says, my lord, that she.
Now, Mr. Chatterjee, while deciding an application for police help, are the opposite parties not entitled to an opportunity to file objection?
They were there.
No. No.
They are
No.
never a press.
Yes, yes.
Never a press.
Yes. Please kindly come to the third paragraph.
Honorable, the defendant might prefer granting time.
Verbally.
Yes, praying for time.
No.
This was the first. Yes.
After
Praying for time for filing written objection.
yes. And by the time it will be flouted.
Mr. Chatterjee, so that is why I'm asking you. Are they not entitled to an
Lord, he
opportunity to
has
file
objected
written
it.
objection?
My lord, if that
That's a different thing altogether.
if that is so, even then I'm entitled to an ad interim order then. If your lordship even comes to that, during the pendency also I'm entitled to an ad interim order of implementation. Looks to the next paragraph.
Application.
The learned advocate on behalf of the defendant verbally submitted before this court that the plaintiffs had suppressed that an appeal was preferred. While making the application, another case was filed by the defendant against plaintiff number such and such, and order status quo was passed. The learned advocate on behalf of the defendant further submitted that the plaintiffs have no status as directors of the company. Comes back to the cause title. Her cause title. Kindly comes back. See how I have been, my lord, described. Presently a director. My lord, whether I am there, whether I am not there is not the subject matter of dispute. Though I can show, my lord, even today in the register of companies, my directorship is still there. And she has admitted that I am the director. You know, so, my lord, my respectful submission is whether they are entitled to an objection, whether they are not entitled to an objection, I am entitled to an implementation. Whether on an ad interim basis, whether on the final basis, my lord, I am not on that. If your lordship wants them to give them an opportunity, I don't have a problem. But in the meantime, my lord, it should not be, my lord, flouted. That's my respectful submission before your lordship. Kindly looks to my application once.
Why it is urgent?
Why was it so urgent for us, my lord, to go? Now, I have an order of police help. They bring in the police and try to throw me out.
They are not aligned with.
They are not, my lord, agreed, my lord, by the order of status quo. They are enjoying it. If they are enjoying an order of status quo, my lord, in my respectful submission, it goes in my favor. Have a look at my application. Page
109.
108.
109.
Starts off from 9. I'm sorry. Please, paragraph 6. Seven. Especially 7. This is where the problem is all about.
Stopped. You put it somewhere else.
Yes.
Yes.
And then she is saying, this is my problem. I can't physically go and stop them. My lord, if your lordship feels, my lord, may I make this submission before your lordship? An order of injunction, good, bad, indifferent, is, my lord, continuing. My lord, if your lordship looks into that judgment, my lord, that line is very important. The said order of injunction is
Give
still
it
in
to me.
force.
I have returned it to you.
Yeah, I'm sorry. Have a look at that.
Which paragraph?
Kindly have a look at the third paragraph. My lord has probably marked it. The last line, it says that the injunction is still in force. I am on that. Today, here also, my lord, the injunction is in force. Whether it's ad interim, whether it's interim, my lord, in my respectful submission, doesn't really, my lord, matter.
Court has a duty to
It's the
see
duty
that
of the court.
orders are not flouted.
Absolutely. It's
Thank
the duty of the court. My lord,
That is
let-
why I have told you. It's the duty
Once-
of this court to see
once
that
your
its orders are not flouted.
once your lordship has, my lord, passed an order, it is my lord's duty to see, my lord, that it is implemented. So in my respectful submission, my lord, there's nothing wrong that the trial court has done. If your lordship was, if they were so serious about filing an affidavit, my lord, they could have done that before. Have a look at the impugned order once. My lord, my learned senior wants to, my lord, show your lordship 122.
122, yes.
That we are in possession.
What is 122?
That we are in possession. It's accepted. Judgment is- Lord, Mr. Shuddha Sattva Banerjee is here.
How is he related with this matter?
My lord, this way.
Yes. But try to exhibit him.
Yes.
Yes.
Kindly have a দিচ্ছি তোকে দাঁড়া এক সেকেন্ড আর একটা কপি করেছে paragraph 24 24 তো 54 দেখাবি 24 থেকে দেখাচ্ছিল আরে জজ সাহেব জানেন তো মাই লর্ড
Yes, it's paragraph 24.
24 and then 54
Then
54 this is where I was harping on and it's my lord's observation as well. It therefore follows that when the rights of the parties have been determined either finally by the civil court or at least at an interlocutory stage in an unambiguous manner, the party can approach the court for police help for protection of the rights declared by a decree passed by a civil court or at the interlocutory stage in an unambiguous manner. So, my lord, there is no ambiguity in what the injunction has been, in the way the injunction has been passed. Injunction is passed and her document shows that I am in possession. Her document shows that I am in possession. So if that is so, my lord, there's no question of flouting, my lord, an order of injunction. On merits, Mr. Rai wants to submit two things, my lord, allow.
yes, yes, Mr. Rai.
62 set aside করে দিয়েছে ultimately rejected.
Mr. Rai, how long you want to continue?
Oh no, হয়ে যাবে আজকে।
Yes, yes, yes.
কালকে today my lord we have
Yes, yes.
tomorrow
Please continue. I asked you how long you want to continue. That is why.
একটা সময় যেতে হবে তোমার ওখানে
Yes, yes.
9:30 যেতে হবে ওখানে
1 p.m. Yes.
and can you turn to page 77
Page.
77
Yes.
this is the letter written by the opposite party hearing to the petitioner, out of which my lord can you consider the second paragraph, transfer of 100% shares. The acquisition shall be influenced by full ownership of Aristocrat Hotel Private Limited and the associated hotel business, inclusive of all assets, titles, interest, and other things. Total consideration amount is rupees 30 crore. An initial token payment 51 lakhs in paid on such and such confirm, and 27 crore will be paid on 10th October 2024 upon my lord can you consider handover position, change of current account signatory, completion of transfer 25% of the company share, appointment of one director. Effective from November 2024, a minimum 25 lakhs per month payable to such and such. And these are the conditions. I was inducted. Now, my lord, can you consider whether as on this day, my learned friend's client has 100% share or not. If she has 100% share in the property,
Mr. Rai, neither I am deciding the suit,
is why
nor I am deciding the injunction application.
saying
The
this.
scope of the civil division application is very, very limited.
That is,
Whether police help could have been granted
yes, that
under
is,
such circumstances.
that is why the business is under the opposite party. Directorship has been transferred. I am the director. Whether she is the 100% director does not know. Whether this cancellation, unilateral cancellation is permissible after acting on the basis of the contract.
Show me those findings in the order dated 19th of August 2025.
August, page 80.
This is how an ad interim order of injunction is to be passed, Mr. Rai. Yes.
That is the subject of
You invited the court to those. That is why I'm asking you. Is this the way an ad interim order of injunction is to be passed? Yes.
Yes.
No, Mr. Rai, I did not go into that since you were trying to point out those documents to justify the ad interim order of injunction. That is why I've asked you.
That is why prior phase, what is the reason? The reason is that
Nothing has been disclosed in the ad interim order of injunction.
that is the subject of
Nothing.
appeal. That is the subject of appeal.
So this one paragraph, after considering, I think this is the best way now to deal with these matters.
Now one can consider the
Everything after considering all the materials on record, this is the order. That's the ad interim order of injunction.
that is not being challenged.
That is why. So you are trying to justify that order. So that you are
I want to satisfy your lordship the grounds which she mentioned that yes, he is the owner of this hotel and pursuant to which these are the. In response to her argument, I am saying this.
Yes.
My plate categorically said, what is the facts? I am in possession, my business has been hampered by somebody else. I approached the court saying that these are the things on basis of which I sought for an ad interim order of injunction. Ad interim order of injunction granted. Now, on the basis of the documents which prima facie appeared that I am in possession and there is something to be happened on such and such day, so I need a police help. Because, and not only that, this organization has came and stayed at somewhere else on road because they are not allowed to enter into the hotel. Be as it may.
Anything more, Mr. Rai?
And why not, as of this day, order of status quo has been passed. Now, what will be if
No, not status quo.
yes,
Not status
so
quo.
peace injunction, there is status quo. That is what. So what will be the effect? Well, can you consider? Today, somebody is claiming to be in occupation of the hotel, and we are also claiming we are running the hotel. This is a claim and counterclaim in both the ways. We are running the hotel privacy.
I think it's best. That order also has to be implemented. Let the police now decide how to.
Absolutely. Take it.
Let the police now decide how to implement.
Yes. What he is doing in that way, what he is
Let the
doing,
police now implement how to be implemented.
that is what, my lord. Now the police is implementing the order of status quo.
Yes, yes. So these two orders are to be placed before the police authorities. Let the police decide which order to be implemented. That is why I asked her, why not apply under 151 for implementation? That would be the best course. Two orders before the police
because
decide, they will decide how to implement.
It's because I am in possession. She knows that well. Not your lordship need not even get into this.
Anything more, Mr. Rai?
Mr. Chatterjee.
No.
Yes, anything in reply?
Lordship, only since I'll just add 2 lines. 100 crore hotel, 100% shareholder.
Madam, don't quote the figures.
Lordship, 1 crore, and he is in possession and he is the owner. He is running the business. LOI cancelled, not challenged. Your lordship,
Those who have submitted,
lordship has observed
anything with legal
judgment.
issues
On
and
the
the
judgment.
judgment which Mr. Chatterjee has
Lordship,
submitted.
in both the
It will be
judgments.
written.
Said that I'm running the business.
I am running the business.
Then somebody
Fifth,
might
fifth,
not be running the business.
Lordship, 5th April order, which has been placed before this honorable court, and interim injunction, your lordship has observed that it is no ad interim. On the next page, your lordship, page 3. The last line,
Page 3, yes.
page 3, The officer in charge of the local police station is directed to render assistance to the petitioners for implementation of the order of injunction
Yes, so that
whenever
here
such
the
assistance will be required. So that
yes, assistance will be required. Assistance when it will be required. So Mr. Chatterjee submits that an interim order of injunction can be implemented with police help. What is your submission with regard to this?
Lordship, at the ad interim stage, now when it is being allowed to Lordship on such facts, when there is suppression of facts, such order implementation, now the learned court, while passing two simultaneous order, the learned court is in scene of both the facts of the entire case. Now implementation of such an order is in a way trying to grant final relief at the ad interim stage. It's
With regard to the other
Lordship,
decision,
other judgment, there is a Lordship, it is the observation here only. The impugned order directing police help stands set aside. The police help is set aside at paragraph 62. Lordship, I don't know why this judgment has been relied upon. Paragraph 62, which is the concluding paragraph, which says, Your Lordship, middle of the judgment. Recently, I was also referring to one such middle of the paragraphs when I was indicated by the Honorable Court that you are reading the observations. Come to the concluding portions. And the concluding is that the impugned order directing police help stands set aside.
anything more?
No, Lordship.
Heard the learned advocate for the parties.
Grateful, my lord.
Yes, yes, call the next matter.
Lordship, may I file the affidavit of service?
Every service. Yes, Mr. Banerjee, you are appearing.
21 minutes.
Yes,
Affidavit of service take to Nienin, item 19.
every service taken on record.
Grateful, my lord.
Yes,
না না 12:30 বেজে গেছে আর কি
yes, yes.
আমি একটু চাই।
12:30 বেজে গেছে
Yes, Mr. Banerjee.
The National Jute Board files a suit against me for recovery of certain amount of money, claiming that certain benefits are
Banerjee, the
with liberty to file afresh.
withdraw with liberty to file afresh.
Yes. That with liberty to file afresh, that liberty that has been granted, I've challenged.
Mr. Banerjee, it cannot be a piecemeal one.
No, I'm challenging the
Cannot
fact.
be a piecemeal one. If withdrawal with liberty is sought for, either it is to be allowed as a whole or rejected as a whole, cannot be in part.
Well, then I'm challenging the entire order. I've challenged the whole order.
Then the suit cannot be withdrawn. They can proceed
Yes,
with that
because I'll tell
suit.
you, Lordship, what happened. National Jute Board files a suit against me, claiming certain amount of money as recovery that they say I have gained as a benefit wrongly under a scheme. Or there is not.
Why this liberty was given?
I'll tell you, Lordship. So then they say a certain adjustment when the suit is filed, suit is shown as above 1 crore, then it's struck off and it's shown as 98 lakhs. The plaintiff is admitted. Then that matter is taken up in a different writ petition. I come up before the High Court. Coordinate bench of this court holds that if you have to really adjust money, you have to file a suit for recovery. You can't adjust money from what is payable under the scheme. Fantastic laws advising them, they get wiser, go and now seek an amendment. So before that they say adjustment has happened. So initially for 98 lakh, then they say it's adjusted, amendment brought down to 18. That 1/8. That adjustment later in a separate matter, court holds that you can't adjust like this. You have to file a suit for recovery of money. That you have to do. That when Mr. Chatterjee must have stepped in, and they filed an application for amendment of the plaint, highlighting the fact that another coordinate bench judgment has held that I can't adjust directly. I have to file a suit for recovery of money. Now, if I file a suit for recovery of money, the valuation is going to exceed 1 crore. This amendment application is filed. The amendment application is withdrawn. Then a 23 application is filed saying, give me liberty to file a withdraw with liberty to file afresh. So, and the order is that yes, there appears to
Banerjee, how are you prejudiced?
So that's
Is
the
it
question.
barred by limitation?
So that's the issue, Milord. Your Lordship will kindly have a look at this judgment. I'll formally cite this for completeness. Milord, 2000 volume 5 Supreme Court cases 458. Milord, the test that your Lordships have applied, that there is a difference between 23(1) and 23(3). That I am not prejudiced is not a ground that your Lordships have countenanced ever. There has to be an exercise of discretion.
prejudice means if it's a question of limitation and other things, yes, one thing you can say.
Now,
That is not so.
I'll tell you, Lordship, what the prejudice is. My lord, the suit is initially filed for 98 lakhs. Then an
Yes.
amendment is carried
Suit for
out.
recovery
Suit for recovery of money.
of
Then
98 lakhs.
yes, amendment is carried out for making it 18 lakhs.
Yes.
So the rest they say is not recoverable. Then relying on a separate order, they file an amendment application seeking that I want to enhance this now. That amendment
was not pressed.
Not pressed. That, now your lordship has it. That amendment was not pressed. Once the amendment is not pressed, him withdrawing the suit with the liberty to file afresh, he is resuscitating something which otherwise he would not have had with him. And this word I'll formally cite it, although I am conscious that in this court I don't need to. Now the pore judgment দিয়ে দিচ্ছি. Kindly see, my lord.
Paragraph 13.
Paragraph 13. The provision of Order 23, Rule 1 CPC is an exception to the common law principle of non-suit. Therefore, on principle, an application by a plaintiff under Rule 3 cannot be treated on a par with an application by him in exercise of the absolute liberty given to him under Sub-Rule 1. In the former, it is actually a prayer for concession from the court after satisfying the court regarding existence of the circumstances justifying the grant of such concession. No doubt, the grant of leave envisaged under Sub-Rule 3 of Rule 1 is at the discretion of the court, but such discretion is to be exercised by the court with caution and circumspection. The legislative policy in the matter of exercise of discretion is clear, and the provision of Sub-Rule 3 in which two alternatives are provided. First, where the court is satisfied that a suit must fail for some formal defect, and the other, where the court is satisfied that there is sufficient ground for allowing the plaintiff to institute a fresh suit for the same subject matter of a suit or part of a claim. Clause B of Sub-Rule 3 contains the mandate to the court that it must be satisfied about the sufficiency of the grounds for allowing the plaintiff to institute a fresh suit for the same claim or part of the claim on the same cause of action. The court is to discharge the duty mandated under provisions of the code on taking into consideration all relevant aspects of the matter, including the desirability of permitting the party to start a fresh round of litigation on the same cause of action. Then it becomes about appeal. Not the same duty again.
That's a different thing altogether.
Yes,
so
then appeals on part I'm not. So Order
Yes.
23 purport. Now your lordship will have a
So
look at it.
according to you, the court has to also consider the desirability of permitting to start a fresh round of litigation.
That's right.
That was not considered according to you.
Nothing was considered. What was
Strategy,
considered?
only one thing, nothing on merits with regard to that, because it's really a non-speaking order. It says after
It's a
considering
discretion exercise by a court of law.
without any
Why?
reasons.
No, there is a reason which I can show your lordship right away. What happens is, my lord, they get money under the scheme from the central government. This is public money. Now, what happened is I adjusted the money with certain other money, my lord, which he owes to me. This honorable court said that you cannot adjust that. The single bench said, division bench said, Supreme Court said. I accepted that. He said, if you want to recover, you go and recover. I have gone back and have tried to recover it.
No.
Yes.
No, but he says that initially it was 98 crores or
But I have
something.
not.
You have
I have-
reduced it by
I have
amendment.
not pressed that amendment. I have not pressed that
That's my
amendment.
point.
It stays at 97.
No,
That is what I'm arguing on.
that was allowed. It became 18 only.
Yes.
That's his
18.
submission.
It was brought down to 18.
18.
After
Then you wanted to amend it
That's
to make
right.
it higher.
Which amendment he doesn't press?
That is not press.
Very well. Very well. Now, what happens is after adjustment, if the authorities find that he has 18 lakhs, which is recoverable, he may not amended that and brought it down to 18 lakhs. Now we've again found, my lord, that it's not 18 lakhs, it's more than that. That's why the amendment, my lord, was my lord, filed initially. Now, why it has been, my lord, not pressed, why it stays there,
That's my
doesn't matter.
Because there are two things.
It's my plane.
Maybe.
My lord.
But Mr. Chatterjee, one thing,
Where is
when you have withdrawn that or not pressed that, some sort of, whether some sort of bar applies or not,
The bar
has to be
applies, that
considered.
bar will apply, my lord, in the suit. The bar will not apply now. Today, my lord, if this order goes, then
No,
the
bar
suit
has to
stays.
apply in this suit.
No,
But because
I am saying,
New suit.
I am saying,
Mr. Banerjee, please, because after not pressing that amendment application,
whether I can again go back.
yes,
Very
with
well.
that prayer of, because now you want to file a
Let that
suit
be
with
open.
that enhanced amount
My lord, I
as
am shortening the
was
matter. I am shortening the matter. It's a point which is open to him, which he will take. Keeps that open to be taken when I file the suit. Why would it be decided at the, may I ask this question to myself, at the time of withdrawal or a liberty being granted? This becomes, my lord, an issue in the suit which I will file. Keep these points open and allow me to file the suit. There is no problem in that. He can't say that I will have I cannot withdraw with a liberty.
that is
What we
withdrawal of
pray for.
liberty. Mr. Chatterjee, withdrawal of a liberty with liberty is not a matter of right.
No,
That's subject to the
I
constitution
bow
of the
down.
court.
I bow
So
down.
you can withdraw without liberty, no difficulty.
Then I
on
bow
that.
down completely.
No difficulty on
But
that.
here is a question, my lord, this is a question of public money. They can't be, my lord, unjustly enriched. And limitation, my lord, is about 30 years.
No, that is what I am
30
saying, that
years.
if there is
So
no,
there
I
is a
was
question.
under the impression
And
if
if
the
I have
limitation
only
does not.
amended it, and if I have only
Limitation is not my issue at all.
Yes.
my lord, even if it was or if it isn't, but whether there is a bar or not, it becomes an issue, my lord, in the suit I will file. Not now in this application order 23. Respectfully submitting. Whether, my lord, just because a liberty has been granted, then the bar is lifted is not the law. I'm sure my learned friend is not suggesting that. He
No,
said, this is the suit. What I will pray for, my lord, by way of that liberty will come up only when I file the suit. Not today. Kindly appreciates that. When I file the suit, then the issue will crop up.
Where is your application for withdrawal with liberty to file?
Page 82.
82?
But may I just indicate one thing, and your lordship will just examine this from this perspective once. Let us say the withdrawal doesn't happen.
When that will start, Mr. Banerjee and Mr. Chatterjee?
I am also.
That is where we are. I asked Justice Bhattacharjee, my lord. His lordship said that we will rise at 12:30. Till 12:30, we will not pass any adverse order, and we'll rise at 12:30.
Because it's 12:45 also.
তুমি আমার নতুন suit file করে দিলো? But I'm agreeable to have this stayed and come back after vacation. Otherwise, he'll file a new suit.
If I
That's
file
my
a suit,
only-
go and contest.
No,
it.
no,
What-
but
there
that's-
is a problem there.
Mr. Chatterjee, this issue has to be gone into.
Then keeps it on Wednesday then.
What will happen?
Because
NJB,
happen
Lord,
is,
they're
my lord,
anyways
my-
filing after.
they are
Mr.
running
Chatterjee
short
has
of
been
money.
brilliant in his strategies. He's
Second,
anyways caught my.
প্রত্যেকটা মামলায় এক কথা বলে আর প্রত্যেকটা মামলা the problem is, my lord, that this is public money. And once, my lord, what they've done is they've under the scheme they were entitled to, my lord, get a certain amount of money.
Well, these are
What
facts
they've
of
done
knowledge.
is,
This has, it is a
great for them. Great for them. বুঝতে পারছি না কি হচ্ছে কি বুঝতে পারছি না really what's happening
বাইরে না বেরোলে বুঝবি regarding what?
whether your lordship would rise, would sit.
No, you said that that will start at 1. You said
One.
only
next matter,
small, yeah. Item number 28, that Puja matter, man.
Treasurer has taken
No,
a
Malad,
decision.
There's nothing to do, man.
Mr. Raut, come
next matter tomorrow.
That passed over matter, come tomorrow. Puja matter ta din.
Item number 22 will come back.
But you are the treasurer, Mr. Ganguly.
Malad, nothing to be done, Malad. Ma Durga, Malad, there is, Malad, if the matter is not moved, Malad, then
Yes, yes.
Malad, here is, Malad, there is a caveat I have served, Malad.
But where is the caveat? Ganguly, unless today I cannot
That's
keep
the
it up.
Sir, kindly keep it up tomorrow at some ballot convenient place.
If it was not 1 PM,
Yes, then
that will
it
be taken up.
I would have mentioned my.
রেখে দিন যেরম জায়গা আছে